Please the court. My name is Martin Payton. I'm representing myself in this proceeding. I've been a member of the Florida Bar since 1985. And during that 35-year period, up to and including today, no client or any other member of the public has complained to the Florida Bar about my conduct. I have a small transactional practice, and I've not only not had any complaints, but also not a single title claim in 35 years. I also learned that they make mistakes. The first mistake by the Florida Bar is that for almost a year of this process, they mistook my identity for a different person with a similar name. Well, after my deposition, probable cause, and the pleadings, we were assigned Judge Coleman as the referee, and he scheduled a conference. At that time, he informed us that he had been assigned this case as the referee because he had previously handled my case, my Florida Bar disciplinary case related to my criminal conviction for battery on my spouse. I said, "Your Honor, that was not me. That is a different person." And he looked at me and he said, "Yeah, it was not you." I asked him if he knew they had the wrong guy, and did that affect anything in opening this matter or moving it forward. He just shrugged. When I got back to the office, I called the Florida Bar and I asked for a supervisor. And Adria Quintella called me back, and I asked her if this had any impact on opening this matter or moving anything forward. She said it was irrelevant. She also is no longer with the Florida Bar. I can assure you that it matters that a person is mistaken for someone who has criminally assaulted, has a criminal record for criminally assaulting his wife, when that is simply not.
We're here on specific charges that have been adjudicated, and the recommendation based on those. And you can proceed however you want, but I think you're better to focus on why you think the specific charges are not supported by the record, and otherwise focused on what we specifically have before us.
For example, do you contest that you directly solicited a client in contravention of the solicitation rules that govern attorney conduct?
Yes, I did not solicit a client. At that time, we contacted the people as an investor, and I was one of 8 people in an investor group. I didn't start representing the client until probably about a month later. So no, I did not ever solicit anybody. These people had $398,000 in student loans. They had a car repossessed. They had no chance of getting out of this situation. I could have said, "Hey, no, I'm not going to represent you," but I said, "Yeah, I'll take on your case," because the very type of people that the Florida Bar for 35 years said that we should try to represent.
Your real estate investment firm that you're an owner in purchased the lien rights and foreclosed on the property that the person owned. Is that correct?
Yes, we purchased property at auction. And then we reached out to them to see if they wanted us to help reinstate their mortgage and work with them to try to sell the property and make a profit that way. When that became not realistic, there was no equity in the property, then he asked me if I would represent him.
You didn't make any filings in court before you had a relationship representing the individual you're talking about.
Correct. We discussed, at the very first thing I filed was a motion to get the reinstatement, which was to find out if there was equity in the property or not.
Was there an attorney-client relationship then?
When I filed the document, yes. And he said as much in his deposition.
So what's the explanation for the September 2016 letter where they said after the filings had been made that you in fact weren't their lawyer?
The initial document was because this is a young couple who was extremely scared. So he looked at the court document, and what it said was that someone filed the document. It was actually the opposing counsel, but it was a non-military affidavit, which is fairly standard in a foreclosure proceeding. He thought there was a military affidavit, and one of the rule violations that I think, let's go back to the trial in this situation. What you have is it's not a trial like I'd ever seen before, or like you'd think. There's no this big finding of fact. What it is Mr. Flicker comes in and he hands the matching trial notebook, and they flip through this trial notebook in chambers about 2 feet apart in rapid fire succession. And I tried to object, because it's just nonsense with no understanding of what happened. The questions are not relevant to the rules. And so they said this is not criminal. Referee Coleman said, "This is not criminal. This is not civil. It's quasi-judicial, and I'm letting everything in, even hearsay, just as fast as you could fill out forms and put them in the record. That's how fast this thing went." The second time I objected, he said if I did it again, he was going to have me removed from chambers. So I sat there, and for 35 minutes, I watched a 35-year career go down the tube.
Is it your contention that there was no conflict of interest?
If I had to do one thing over again, I would not submit the first contract with myself being the president of the
So
company.
you recognize that there was a conflict of interest and you did not get a waiver. When you take off your attorney hat and put back on your real estate investing hat, when you approached the Gilks originally, I understand it wasn't to represent them. You're saying it really was to try to get the property, correct?
We already had the property. We purchased property at auction.
Well,
So we reached out
deal
and tried
with,
to help them.
to deal with the first mortgage,
Correct.
to get it without that first mortgage, because there was no
To work on paying off or
right. So you were representing your own interests, the interests of your real estate investing firm, in trying to work this out so that you could get rid of the first mortgage and the property that you had acquired. You didn't need to speak with him in order to advance your personal interests in trying to get rid of the first mortgage and the property that you had acquired.
May it please the court, my name is Lindsay Ganand and I am counsel for the Florida Bar. Mr. Payne engaged in egregious cumulative misconduct over a 2-year period, and he did so for the interests of himself and his company. The record is clear that Mr. Payne directly solicited clients and made no less than 11 misrepresentations to those clients, to opposing counsel, and to the court. And I would like to bring to this court's attention a misrepresentation that Mr. Payne made to you today. When Justice Lawson asked, "Did you contest that you directly solicited a client?" Mr. Payne said, "Yes, I do. I reached out to them originally as an investor, and I did not represent them until approximately a month later." That is inconsistent with his testimony and the filings that he filed in that foreclosure matter. He purchased the property on August 19th, and he filed his motion to compel for reinstatement on August 25th, 6 days later, not a month later. So already there's contradictory evidence in front of this court. There were at least 11 misrepresentations made throughout the entirety of this 2 years. The referee in the matter found his conduct to be deceitful and dishonest, evaluated the credibility of Mr. Payne, and based on that conduct, applied the standards and the case law and determined that disbarment was the appropriate sanction. You can see Mr. Payne's email to the Gilks saying, your case, the foreclosure case, you're going to be defaulted and your house is going to be foreclosed upon if you do not correct this and tell the judge that I represent you. Here's an affidavit to sign. There are 3 cases, Your Honors, that do support a finding of disbarment in this case. That would be the Florida Bar v. Klein and the Florida Bar v. Carresco, which were cited in the report of referee, as well as the Florida Bar v. Kane, which was cited in Mr. Payne's initial brief. In all 3 of those cases, this court disbarred respondents for engaging in conflict of interest and misrepresentation, and they did so when the respondents had no prior discipline, the same as Mr. Payne. The referee's report is based on competent, substantial evidence. All of the findings are based on competent, substantial evidence, and the sanction is reasonably supported by the case law and the standards. Mr. Payne has failed to show that either one of those are in error, and for that reason, we ask that you accept the referee's recommendations.
For almost a year, the Florida Bar thought they were prosecuting a different person with a similar name. So what impact that mistake had on my life, we may never know.
Sir, I'm sorry for interrupting, but do you have a response to what opposing counsel said about the fact that essentially the record contradicts something that you just told us about the 2 months?
I don't think there's any contradiction.
Well, she said that it was 6 days later that you filed that, and you told us that it was a couple of months or a month. Or
I don't think it was 6 days later. 6 days. The certificate of title may came out at some point, but the auction itself was farther back in August, and there was a time gap. Disbarment is the same penalty as the same wrong as the death penalty. And I think that the action in this case and the conduct in no way rises to that level.
Right. We thank you both for your argument.
This wasn't just shoplifting. This was organized betrayal. A retail theft ring moving county to county, hitting stores over and over again, and right in the middle of it, Alexis Cooper. 10 separate thefts. Nearly $9,000 tied directly to her, but zoom out's hand. This crew caused over $90,000 in losses, and yet, somehow, she walks into court with a deal, a 12-month cap, even the prosecutor admits. I don't know what I was thinking. That's when the judge steps in, and everything changes. Your criminal history is ridiculous. Page after page after page. And when she tries to downplay it saying she didn't know what was going on, the judge shuts it down instantly. Because there's video, different stores, same pattern, same crimes, no excuses left. You are very lucky, because you deserve a lot more. And just like that 12 months, the maximum allowed. But this wasn't just a sentence. It was a warning. 2 felony convictions now. 1 more Stepania. She's not going to state jail. She's going to prison. So what do you think? Is this a second chance? Or just a pause before it gets worse? Drop your opinion in the comments. And subscribe for more real courtroom moments.